item for the children.
Thomas, counsel for the department.
Eva Kopis, foster care specialist with NDHHS.
Michael McFarland, representing Mother.
Very good. All right. Ms. Hines, we're ready for your report whenever you're ready.
Thank you, Your Honor. I got to meet these.
Do we need him?
Okay. Yes, he represents bio dad of the older two.
Ah, right, very good. Okay. All right. Okay, so do we have Joseph Miller here?
Yes.
Joseph, great, very good. What about Guy Avalos?
Yes, ma'am.
Thank you, welcome.
And the two older children are here too. They're on zoning code.
Thank you. Welcome, Mr. Brooks.
Your Honor.
Your client, Mr. Miller, has already introduced himself. He is here. Would you like to put your appearance on?
Michael Brooks, I'm appearing on behalf of Mr. Miller, Joseph Miller. He is the legal father of the younger child and the bio father of the older child.
All right, Ms. Heiss.
Thank you, Your Honor. I was able to meet these four wonderful girls. Wow. You're missing all the fun out in the field. So as you recall, all four girls are staying with Mr. Avalos, and they, two younger are his biological children, two older are not, but this is where they call home. This is who they call dad. So all their needs are being met in their current placement, which can be no small feat. Dad has to argue for the family gets food funding on a card, a debit card, and he has to argue even to get the food card from mom to get milk for the kids, and he has to get gas to get the milk for the kids, and it's a big chore. So we'll be looking forward to supporting him in this placement. According to the girls, the older girls, there have been no counseling appointments made towards the goal of introducing biological father and seeing what his role can be. But we're early in the case and we're just a disposition. It's my information. There was a new assaultive incident yesterday where mom punched dad. He's got a big, but we'll let the criminal case sort that out. I'm sure there'll be a police investigation and a police report. The children's needs are being met at home. You know, these kids have been fooled before, and they're a really good test for me to know if mom's doing well or not. I would suspect that mom is communicating with the children outside of visits, and I would ask the court to mention again, as you did in the court order last time, that contact not happen between visits. This is a time for mom to get better, for mom to do her case service plan, for mom to really benefit from services. And if she doesn't choose to change, or if she can't change, there isn't going to be a reunification. The kids have had it. The little ones are benefiting very much from the visits they have with mom. It is in a supervised capacity. I think maybe there could be more depending on resources of the family. Those little ones are very, they look up to their mom, and they haven't experienced as much as the older kids have, but mom was going to get treatment, and whether she did or she didn't, it hasn't taken yet. Mom has to decide to make a change or this isn't going to work. The older kids aren't going to be fooled again. They live through an awful lot. There are just minimal resources to go around. You know, these kids have some clothes there's one bedroom for 4 girls, and it's all very neat, but they each have the privacy of their twin bed. That is it. There aren't play areas, there aren't outside, there's a little bit of outside areas, but this is a very marginal family, and mom's bad behavior cannot be tolerated. There's not enough resources to go around. These kids need lunch, they need tennis shoes, they need milk. Dad is made a real healthy dinner for the kids. They were all sitting there eating it, and it was really nice to see this house, but mom can't interrupt that during this case. She has got to let them have some peace, some growth, get to school, do what they need to do. That's enough for this family. Mom's problems are too much. So we encourage her to follow this case service plan that has been laid out and make the changes necessary to reunite with her family and become an asset to the family again and get back on to raising the kids that she brought forth in the world, and it's her responsibility. She needs to get back there and make their lives good. So that concludes my report for today.
Thank you. Ms. Thomas?
Thank you. For purposes of initial disposition, I would ask Ms. Kopis to be sworn in.
Thank you, Ms. Kopis.
Ms. Kopis, can you please state how you are familiar with this matter?
I'm the foster care case manager that was assigned the case after the initial removal of the children.
And since the removal and the petitions been brought forth, have you had the opportunity to visit with the family and speak with the respondent parents?
I've had an opportunity to speak with all the parents, whether face-to-face or over phone calls. And then I've also had an opportunity to meet with the girls and talk to them as well.
And what is the current permanency goal for the children?
Reunification for the 2 older children, family preservation for the 2 younger children.
And all 4 children, as Ms. Heiss stated, are with Mr. Avalos, is that correct?
Yes.
And do you believe that that is the least restrictive environment to ensure their safety at this time?
It is.
And do you believe that he is exercising the reasonably prudent parent standards as it relates to raising the children?
Yes. Mr. Avalos has tried to maintain some normalcy for the children throughout this process, has tried to ensure that they have stuck to a routine, stuck to their normal routine, so that they are not as displaced as the case typically would allow or would typically do for a child.
And as a result of the reunification goal the permanency goal for the children, were you able to speak with mother about the case service plan that you submitted with your court report?
Briefly, we talked specifically about the court report, and then we've had a separate conversation in which we talked about services and what she thought would be beneficial and what I thought would be beneficial.
As it relates to the court report and the attachments that you provided, are there any updates or modifications that you need to make to any of those documents?
I do have a letter which mother provided me. I attempted to make sure that all parties have it, so I apologize if that did not happen, indicating that she has been in therapy since August 10th, that she is still currently participating. I did not get that letter until after everything was submitted, but I do have additional copies so that everyone can have them. The only other, I think, new development was that I did receive a phone call yesterday from Mr. Avalos alleging that there was an incident in which mother attacked him in his vehicle. I'm very concerned about that, given that mother is in treatment and that we have another incident in which she is also threatening another parent.
And you just mentioned another incident. One of the documents that you included is a police report. Is there any additional information that you would like to highlight for the court's attention on that point?
I don't have any other things on that point. Well, I apologize. I did have a conversation with mother about the allegation about her allegedly threatening to harm Mr. Miller. She did indicate that she did make those statements, but that she had meant them out of frustration, and that she was not serious and did not have an actual homicidal intent. So we had a conversation about words matter, and that is part of how this case developed. Was a statement was made that caused children to fear for their life, and that she did not have the luxury of making statements like that during this case.
Thank you for that update. And as it relates to the case service plan with mom, do you believe that the elements that are included in that are sufficient to address the conditions that cause the family to come under the court's jurisdiction?
I do.
And to date, has mom participated or engaged in any of the voluntary services?
She has, because she has already started in her mental health services, and she has already started with medication reviews, and she has been open with the department about the next coming services, and she's asked good questions about referrals and how the process works. And so other than the therapy and the medication review, she hasn't started services, but she's definitely engaging with me and definitely asking questions.
Great. And I noticed in your report that there are referrals made for the trauma assessments, and it looks like maybe there's one a week for a month or so. Are the children, or have any referrals been made for individual therapy at this time?
They have not been made for individual therapy at this time. The hope was to wait to see what the trauma assessments recommended so that we were not duplicating services and that we were having a good start base of where the girls were at.
And have you had the opportunity to speak with them or the parents about how they feel about that plan moving forward?
I've had an opportunity to speak with Mr. Miller about therapy. He believes that they should be started sooner rather than later. Did not have great detailed conversation other than that all parties do agree that they do need therapy and that it does need to start sooner rather than later.
Is there anything, as it relates to parenting time, Ms. Heiss had made a comment that the younger children are benefiting quite a bit from that parenting time with mom. Do you have any recommendations or plans to modify parenting time?
So initially, the two older children did not want to visit, so we had not had any plans to modify or change parenting time other than what the court has right now. Mom is in the beginning of visiting and she does do well. I do not plan to change any of her visitation anytime soon.
Thank you. Is there anything else you'd like to bring to the court's attention at this time?
The department is requesting that mom do her parenting time during the work hours. We do believe that she has demonstrated a behavior that does cause a safety risk, and I cannot guarantee the staffing and the logistics of doing a parenting time after 5 o'clock and that will have all the security measures in place.
Would that interfere with any of the children's like extracurricular activities or anything?
It doesn't. Mom recently gained new employment and there appears to be a conflict there. I did have a brief discussion with her asking if she could inquire with her employer and did her employer understand the court case that she was dealing with. She had indicated that her primary site did not know, but that the temp agency that she was working through did know. And so at this point, she said that she would inquire with work.
Okay. So the 4 p.m. parenting time may not, or may be in conflict with her current work schedule, that if I'm hearing correctly?
Yes, she would like to move the visit back an hour.
Okay. And if that work is not agreeable to allowing her to have that time off, is there a backup plan to ensure safety of all parties involved?
We would have to have an FTM to discuss it further, discuss the safety measures that would need to be in place. And then I have made additional referrals to some of our private providers that provide parenting time so that hopefully one of them can provide different hours or different means for parenting time outside of the department's hours.
Thank you for that information. If there's nothing else, Your Honor, at this time I'd move to admit the court report with the attachments.
No objection.
Brief word here regarding service, Your Honor.
Okay, go ahead.
My client who called me this morning indicated she hadn't been served. Did you serve her 7 days prior to this? And if so, what manner?
No, I did not. We discussed it. I did not hand it to her until we met up today. This is the first time I've seen her since the court report was written.
Okay, Your Honor, I do have a problem. My client hadn't had a chance to read it. I emailed it to her this morning, and she would like more time to read that. Maybe we could adjourn, so my client would have that opportunity to do so.
Ms. Kopus, is there a reason you didn't include the parent with your email service to the rest of the parties?
I did not have an email address for mother, and generally I discuss it with them in person so that we can go through, like I did today when I went through with her, all of what the expectations would be for her and what we were looking forward. Like I said, we discussed the services, but no, I had not given her the actual plan.
What about the court report that you prepared?
I gave it to her today, so that was not done ahead of time.
Is there a reason why?
I had not seen Mother, and my mom had moved during it. Mother had moved during this process, and so I had a moment of trying to find her. I do know where she's at now and do have the address and means to communicate with her.
All right, we typically just ask a parent to have an email address available so that when the email goes out to the attorneys, it also includes a direct email to the parent. Would you be able to accomplish that in the future?
Yes, ma'am.
Very good. As well as file a proof of service so that we know when it was served.
Yes, ma'am.
What I would ask you, Mr. McFarland, is are you asking to adjourn for like 15 minutes or to a different day?
If you have a hard copy, if we could have a hard copy provided to my client, 15 minutes would be fine, Your Honor.
I was going to ask as well.
She has it now, but Captain Shopshelter brought it over.
I do have a hard copy.
All right,
I
good.
gave that copy to her today.
Oh, you did? Okay, so.
Does Mr. Miller have his? Could we do his while we're waiting?
I'm happy to ask Deputy Ames to make some copies for us. He speaks copier. The case service plan also I have here is not signed. So Mr. McFarland, you might want to take a few minutes to talk with your client about that as well.
I did. I have gone over the entire case service plan and she does have a couple concerns on that. We did discuss that this morning when I read it to her.
Okay, all right, yep. So we're gonna take a recess to let all those pieces fall into place. Deputy Ames, here's my copy, so that we can get a copy done from Mr. Miller. Mr. Brooks, do you need a copy?
Yes, I do, Your Honor.
163. Okay, we're back on the record, having given Mr. McFarland a chance to talk with his client and Mr. Brooks a chance to talk to his client, and I now have a signed copy of the case services plan. Anything else for the record, gentlemen, before we resume?
No, thank you.
Any further objections to the admission of the court report?
None.
I have no objection either.
Thank you. They are received then. The exhibit, singular exhibit, is the, that I have is the police report. So if you have a letter, I think you mentioned in your testimony that you wanted me to also receive.
I have a copy for the court, Your Honor.
Okay, Deputy Ames, if you wouldn't mind. Any objections to the addition of that exhibit?
No.
All right, thank you.
I've read it, showed it to my client.
Thank you. It is also received then. Thank you.
Ma'am, the two older girls, can't use their names, they're full sisters, right?
My understanding is.
Now, one of them is the legal, my client is the legal and biological, the younger one, my client is the legal and biological father as a matter of law, right?
That is my understanding is.
The older one is not, is that correct?
That is not my understanding.
I can't hear you.
That's not my understanding. My understanding was that he was the legal father to both girls, both of the older girls.
Well, if you look at the birth certificate does not have his name on it. Do you understand that?
I understand that. There's also a friend of the court order pertaining to him and the girls.
There is a friend of the court order ordering his paternity in this matter?
I am not confident whether it was ordering paternity. The documents that I saw were friend of the court were regarding his, we're naming him legal father, and it was in regards to visitation in both girls.
Is he paying child support on both girls?
My understanding is that he paid $7 in child support for both girls.
Yeah, but I mean, is he paying child support on both girls?
I am unaware.
Assume he is not the legal father of the older child, okay? Would you check into that? And if he is not the legal father, could you facilitate providing to both parties an affidavit of parentage, which would make him the legal father? At least would you inquire of each party?
Absolutely. That's well within the scope of what foster care and the department can do. It was just my understanding that he was already established. So absolutely, if that can be rectified, we can do that.
Well, I have reason to believe he is not. And I think I would like to get that cleared up. You are aware of my client's position about where he has been for the last 6 or 7 years?
I am.
And that he feels he was his parenting time has been interfered with by the mother?
He does.
Nothing further.
All right. Questions, Mr. McFarland?
I do. My client indicates his food card is for the benefit of the children and herself. Wondered what your thought might be if the individual who's watching the children, if he could provide you a list of those food sorts that he might need, so she can purchase them on the card and maybe have an exchange where you could deliver them or somebody could deliver them. What are your thoughts on that? So there's no personal contact between her and him.
So we've advised him to apply for his own assistance. The AP worker who's assigned to mother's case has already been informed that those benefits are actually no longer hers, and that the children have been removed out of her household. That does take some time to catch up in the system. I'm not quite familiar with how they process those applications. I just know that it takes several weeks before we're informed that change has actually finally been made. So I have made them aware that that change needs to happen sooner rather than later so that this does not become an issue moving forward.
So he does not, going forward, need any food from her. Is that what I'm hearing?
Once his benefits initiate, he should not. As of right now, mother is receiving the benefits that should be going to his household.
So what I'm saying is that if he needs food until he gets the own card, she's willing to buy whatever is needed and then have somebody transfer those over. Your thoughts on that?
She can bring me anything that she believes the family needs and I'll ensure that they have them.
Okay, I'm just saying, I don't know how she would know without being told if they're out of eggs, if they're out of milk, etc.
We will work with father so that that does not become an issue again.
Okay, good. Parenting time. I know we're in the holiday season. I know we have Thanksgiving, Easter, or Thanksgiving, Halloween, Christmas, birthdays, children's birthdays. Those aren't addressed in the parenting time at all. How would you propose that we bring some type of holiday or birthday time with mom around those issues?
Mom's visitation right now is supervised. I would request that it remain supervised. I'm not confident how logistically to address those. Mother, even while in services, has demonstrated unstable behavior, and so I need to see her demonstrate that she can be stable in order to attend those things.
Okay, now she has a psychological evaluation this Friday, correct?
No.
Okay.
She is participating in an alienation assessment ordered by this court. She has not been referred for a psychological evaluation.
That's something you're going to do?
It is something that is requested in the case service plan, and that is something that, yes, I will be referring her for.
Okay, have you already called to get that started?
I have not.
Is there a reason why not?
Typically, we wait for the court order.
Okay. And then the psychologist is going to have some recommendations that she follows. And if she does that to your satisfaction, are you saying that you would consider expanding parenting time for the holidays and birthdays?
Absolutely. I mean, if mom is showing progress with her service plan, that is always the goal, to expand parenting time to support reunification.
Okay. Attending school activities. There's a volleyball game. Can she participate by watching it in the bleachers?
We would have to have a very strict understanding of that there would to be no contact. There would be no hi, there would be no talking briefly to them before or after the game, or just scooting by to say hello. It would be very specific that she would be allowed to watch the game, and that would be it, because her parenting time is supervised by the department, and I would not have means to be there.
Apparently, there's band boosters, and one of the girls is in band, and if mom does some things at games, perhaps, and money is given to the band, she would have, if she had no contact with her daughter, would that be something that she could at least discuss with you, and you guys can maybe
Absolutely.
talk about that?
Absolutely.
Okay. I think we discussed everything. Thank you.
Were Mr. Miller and Stephanie married at one point?
I don't have knowledge of that. I'm sorry.
Okay. The petition says that alleges that the children are legally his due to the marriage of the parties.
I apologize. I do remember reading that in the petition.
Okay. So then, mother is living in a residential environment, isn't that true? An institution type of facility?
Yes,
And isn't food provided there?
I'm unaware.
If it is, there's no reason for her to keep the food benefits. Could you organize getting the EBT card to the family?
Yes.
No contact, the judges ordered last time, no contact outside of the visits. Would that include not responding to the children's social media posts?
Yes.
Do you think it'll benefit the children to have a break in that extra communication?
I do.
Okay, thank you. I have nothing further at this time.
Redirect?
No.
Two questions.
Okay, wait, let's ask
sorry.
Ms. Thomas, tell us if she has any redirect first.
I don't, Your Honor.
All right, Mr. McFarland, recross.
Yep, briefly. You're aware my client's at a domestic violence shelter, correct? There's a possibility that shelter may offer supervised visitation services. Could you maybe reach out to that shelter and see if they might do that to accommodate my client's working hours?
Yes.
Okay. My client, apparently she works Friday, she gets out earlier, but that's when she does her therapy, is when she's off of work. Is that your understanding?
I do not know.
Okay, is that something that you perhaps want her to meet with you, or maybe you also meet with somebody from the shelter to discuss that?
We haven't even met with them from the shelter to discuss it further with mom. We can actually include them in part of our family team meeting to ensure that all the providers are there.
And they may also be providers of services that might be beneficial to her. Is that a possibility?
I'd be willing to explore that, yes.
Nothing further.
Okay, thank you for your testimony. You may return to your seat.
Thank you.
Any other witnesses today, Ms. Thomas?
No, Your Honor.
All right, Mr. Brooks, the mother in this case has entered a plea. You would appear we are proceeding towards trial for your client, is that correct?
Yes, but I may be able to correct that if I can put my client on the stand. He might be prepared to acknowledge the allegations in the petition and avoid this trial.
All right. Well, we'll conclude our review first and then we'll come back to that. Mr. McFarland, do you have any witnesses today?
No, Your Honor.
Ms. Hess?
No witnesses, thank you.
All right, very good. For purposes of the review, is there anything else?
No.
No.
Very good. All right. Ms. Heiss, what are your thoughts on the request for the mother to be able to attend the events of the children?
I don't think that's a good idea right now. I just need a clean break. I need them to participate in their athletics and their band concerts without this drama. And when mom benefits from services, I look forward to the day that she can participate without drama. And that's what the children are indicating.
Thank you. All right. Any comments before I make findings as it relates to the review, Ms. Thomas?
No, Your Honor. I believe that everyone has reviewed the case service plan, and at this point, we would just ask that the court make that part of the orders moving forward.
I know the court is aware of my client's concerns based upon my line of questions. I'll rest with that.
Anything else today, Ms. Heiss?
No, thank you.
Very well. Well, the court finds all parties were given notice for purposes of the initial disposition. Ms. Avalos, I have reviewed the case services plan. It has also been reviewed by Mr. McFarland with his client, and it does appear to target the issues that brought the children into care, and it will become part of the court's order today. I do find Ms. Kopis in satisfaction of her obligations, as well as Ms. Heiss. Thank you, ladies. As it relates to the parenting time request, I'm going to allow the department to continue to make the arrangements necessary in order to allow the child to visit with the parent. It seems like, frankly, there are a lot of moving parts to that. And so for me to weigh in on that from the bench may be more harmful than helpful moving forward, considering the fact that you've agreed to explore, for example, some parenting time supervisors outside of the agency, for example. So I'll leave it to you, and I'll ask you to do a little family team meeting as you suggested, with the participation of anybody that she would want to help with the supervision, including those individuals from Catholic God. Of course, be sure to include Ms. Heiss as well. And take into account, obviously, any preferences of the parent who has the children in his care, as well as the children. They are certainly old enough to express their own preferences on parenting as well. I will go with the recommendation of Ms. Heiss as it relates to the attendance of extracurricular activities. There will be no contact with these children outside of the time that's been sanctioned by the department and the caseworker. Once we get the trauma assessments back, there will be a bonding assessment received in addition to those. So you will be expected to participate in that. And if there are any recommendations out of that, that will be reviewed by the court. I'm still looking for a parenting time recommendation. Hopefully the alienation evaluator will take that up. Otherwise, we'll be looking, Ms. Copas, for you to be consulting with perhaps Ms. Renee Moore in light of any recommendations from the parental alienation evaluation, as well as those trauma assessments on parenting time. Okay. That includes, of course, also for Mr. Miller, but we'll get to his case in a moment. It would appear that the issues that brought the children into care continue to present a risk of harm associated with returning them to the care of their mother. We've had a couple of assaultive incidents very recently that demonstrate that despite her engagement in services, there are still some challenges that she needs to overcome in order to show that she is able to provide a safe environment for the children. They will remain under the jurisdiction of the court, placed with Mr. Avalos pending further proceedings. We'll have our next regular review in 3 months. 1:30. If there's no conflicts with your schedule, then I think we'll go with what works for the family and the children. And we'll do 1:30 on Tuesday, December 12th. That will be our first regular review. I look forward to the updates at that time. As I indicated, the children are placed with Mr. Avalos. That is the safest and least restrictive under the circumstances, and they will continue placed there until December under the directives of the court and the supervision of Ms. Copas. Unless there's any questions, that's it as it relates to the review. Okay, let's talk about your client's pretrial order, Mr. Brooks.
Sorry, Your Honor, I didn't hear you.
That's okay. I was just saying, let's talk about your client's case.
My client's position, Your Honor, is this. We are prepared to admit paragraphs 29 through 32 with the understanding that everybody knows he has been significantly interfered with in his ability to parent his 2 daughters because of the children's mother's odd, even deranged behavior. Given that, we are prepared to admit it with that understanding. I also would like him to clarify the status of particularly the older child, ZM, because it's obvious that everybody's confused by what that status is, and I think I can have him explain it.
I have in my file, Mr. Brooks, a parenting time order from front of the court. It does not list the children specifically, but does suspend his parenting time. I also have 2 orders from the probate division in Ohio addressing the issue of the children's names. So it would seem to me that he has been established as the legal parent to Z and K. They were married, I believe, at the time, and the divorce case 11-36637 does seem to address the parentage.
Then I'm not going to worry about it.
Well, the children might have been born before that marriage, though. I see that the divorce date was 2016, but I don't see the marriage date.
My client informs me that the older child was conceived and born prior to the 2 of them being married. The younger child was conceived and born after they were married. But if you have something from the state of Ohio that says he's the legal father, biological father, I'll go with that.
I think it's a Lenawee County divorce case that makes him legal for both children.
Well, I suppose that's a question. The last thing I have in that particular case is, or the only thing I have that was attached to the petition is the parenting time order. And it does not actually address the children directly, it just addresses the issue of parenting time.
The agency has the divorce.
So I went and looked a little bit farther back into that just recently in the last week. And I have one from just before that one that does give their two names.
Can you give us your name for the record, your appearance?
Sorry, Sarah Harvey, DHHS.
Thank you. I should have given you the opportunity. Would you mind passing that to Mr. Brooks so he can look at it?
There's nothing in here, Your Honor. Dave, if you want to show this to the court, specifically indicating that the older child is the legal and biological child of my client.
Do you wish to, I can take a break and you can pull this file and look at it if you like. This does seem to address parenting time with both of the children.
It does.
So he obviously has the legal right to parenting time. Do you want to take a break and pull that file, or how do you want to?
No.
All right. Are you satisfied that this is enough information for the court to conclude that he is the legal parent?
Yes.
Very good. All right. All right. As it relates to the request for the plea, Ms. Thomas, do you have any objection to that on the terms that were outlined by Mr. Brooks?
Your Honor, without the parenting, the parental alienation assessment, I'm not going to concede that that's accurate, but it's also not in the petition. If he's just going to admit to the specific allegations, I have no objection to that.
Well, I think he has a duty to get into the court and fix it if someone's denying him parenting time. So I think for what it is, if he admits to 29 through 32, I think there's arguments on both sides that mother alienated and he did nothing about it. So I think the court can take that both sides.
I guess we will not do that today. It just makes a messy record. I withdraw the offer, Your Honor. I would simply say this. My client's position in this matter is that the court should take jurisdiction, certainly of the biological mother and biological father, my client. His goal here, after consultation with me, is not to start getting court-ordered parenting time with a 16-year-old and a 14-year-old girl. His goal here is to be given access to the information about therapy treatments that are being given to his daughters, so he is aware of what's going on. He, like me, is sensitive to the fact that given the upbringing these girls have had, it would be very easy for them false to accuse him of inappropriate behavior, which is, we all know, is a very difficult claim to refute. And so we are not trying to get parenting time with these teenage girls, but we would like access to what's going on with their treatment, which seems like a reasonable thing to me. That's it. But with that having been said, I guess we'll move on and just have our trial when the time comes.
All right. Are you satisfied with the information that was provided today? As I understand it from the review, they are not engaged in counseling at this time, but there is a trauma assessment scheduled for them to take into account any recommendations out of that, as well as
we understand. We just want access to what the results are, like everybody else in this room who gets it.
Yes. Well, and the court is invested in ensuring that that happens, as you saw today.
That is his goal.
Mr. Miller's been invited to the CTAC bonding assessment and has not responded to the agency that's preparing that. So if he wants to be part of it, he needs to participate.
I was never made aware of any of this.
Could you, well, we're on the record yet, aren't we?
We are. Do you
When
want
we go off the record, could you give them your phone number and address?
Yes, they have it, but yes, I will give that to them.
Okay. All right, very well. We have, I think, just, let's see,
That's her.
a bench trial schedule, Mr. Brooks, for October 10th at 8:30 PM.
I think it'll last about 30 minutes.
All right, so we're prepared to proceed at that date on that, at that time? Ms. Thomas, would you agree you're prepared to proceed on the 10th?
Yes, Your Honor. Let me double check. Okay, yep.
Ms. Heiss?
I'm set for that time too.
Very good. Deputy Ames, could you swear in Ms. Harvey? I do want to ask her a little bit about, in the last order, Ms. Harvey, we had addressed perhaps at the time evaluation. Could you tell us a little bit about any progress that you made on that front?
Yep, the referral was sent in the next day to Dr. Park. I received an update yesterday. I reached out to Dr. Park to ask him. He said he's already seen both of the girls and that the mother has her appointment on Friday. He said that he had reached out a couple times to Mr. Miller and had not heard back. I indicated that to the foster care worker, Eva, and she sent Mr. Miller a text with Dr. Park's information so that he could reach out the other way as well.
Okay. And have you received updated information from him today as well?
I have not received any further update from that.
Okay. What about from Mr. Miller?
Just Mr. Miller handing me his number and saying that he hadn't heard from anyone yet.
Okay. Very good. Any other questions, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
And without spreading it on the record, do you have a phone number and address for Mr. Miller?
Yes,
Have you confirmed that information with my client?
yes. We have spoken a couple times and he's confirmed his phone number and his address.
All right. And you've been told by whoever is conducting these evaluations that he has been unable to reach you?
Yes. That he has not returned a call.
Thank you. That's all.
Any questions?
You didn't get an updated address today from Mr. Miller, correct?
No, I believe it's the same address that we have.
Okay, so
Yes, they said.
Eva gave him the contact information so Mr. Miller can call in to Dr. Parks and get his own schedule instead of waiting to be contacted.
That's my understanding, yes.
Nothing further.
Thank you for your testimony. May I return to your seat? Anything else for today as it relates to Mr. Miller's case, Ms. Thomas?
Just for the record, we did provide a witness and exhibit list, and then I believe it has been emailed to Mr. Brooks' office, the custody documentation that we do have. I think that I know that there's an agreement that he is the legal father of the two older children. I think that a copy of the judgment of divorce would be also beneficial in this matter. So I do intend on trying to locate that and provide that to Mr. Brooks and Ms. Heiss as well. But otherwise, we're ready to go forward in October.
Thank you. Anything else for the record today, Mr. Brooks?
No, just that afterwards, when we're off the record, let's see what information everybody has.
Okay, very good. Anything else, Ms. Heiss?
Your Honor, I would just indicate that the children are very marginal on financial ability to function in their world. And if I were the legal father of the children, I would be communicating with Eva, the social worker, to see if there's any way he could provide something for the children. They're really great kids, and I'd love to see them have what the other kids at school have: school supplies, clothes, opportunities. It's just a suggestion. I know he's court ordered into child support, and somebody says that's about $7 a week or something, and I'm just encouraging him to consider that the children are pretty close on food. This is not a funded placement, so Mr. Avalos is not getting any money at this time to have those 2 children in his home. And it's a beautiful home. It's a lovely, warm, comfortable home. It's where they want to be, but there isn't very much money. They take the bus, for example. They have school lunches and that kind of stuff, but I'd like to see them have a little margin of comfort if that can be managed in any way. Thank you.
All right, the court finds all interested parties were given notice for purposes of today's pretrial, and the case does seem to be prepared to move forward to trial on October 10th. Unless there's anything else, we'll continue with the prior orders, including those evaluations, and we'll see you back on the 10th.